Hi, everybody, and thank you so much for joining us today. We're going to get started in just a few moments. We're going to give people a little bit more time to log in because we are seeing there's a lot of people still waiting. All right. So before we get started, we want to thank you all for being here. We did want you to know that there are two handouts actually in the handout section. They are exactly the same. So you do not need to download both handouts. Pick one, whichever one makes you happy. Those are the slides we are going to be going over today. There is a lot of information for us to cover. So we want to make sure you do have a copy to follow along and to refer back to in case you have any questions. We had an issue with those last time, so we wanted to make sure that you definitely got one. So we did attach it twice. And then the webinar today is going to be covering California only. So last week we did cover all the other states or the ones with applicable regulation updates. So this webinar is for California only. If you are in a state that is not in California and you have questions regarding updates, you can absolutely reach out to our team. I saw that question come in the questions box, so I did want to address that before we get started. All right, now it is time to officially get started. First, I want to start by introducing myself. For those of you who don't know me, my name is Adina Glincher, and I am the Senior HR Services Advisor here at PayEntry. I am not an attorney, therefore nothing we tell you today or in any of our webinars should be misconstrued as legal advice. We are HR professionals, and that is the advice we are giving and the information we are providing. For any questions about the content of the training, we are going to ask that you reach out to us via email for this webinar particularly. You can reach us at hrservices@payentry.com. But we have a lot to cover, like I mentioned, and we will likely not have time for an FAQ section. So please feel free to email us any questions you have, or after reviewing the handout, if you have questions, feel free to email our team. All right, so before we begin, we did want to let everybody know that the information provided in the webinar today is not an all-inclusive list of all federal and state updates, nor is it an inclusive list of California specifically. We covered as much as we can. For any state or company specific questions related to the information provided in this webinar, please do reach out to us via the email at hrservices@payentry.com. And please make sure you do reach out to your dedicated HR professional for specific questions about your state updates. If you don't have a dedicated HR professional, we can help you there. Reach out to us and we can tell you more about PayEntry HR services. All right. Now it is time to dig in. So today we are going to be covering New Year's new laws for California, and we're going to start with some general updates. So we're going to be talking about protected time off and scope of coverage, wage transparency, a few COVID-19 updates, including workers' compensation, workplace posters, exposure notifications. We're also going to be in the protected time off category talking about bereavement leave. There's a big update there. We'll be discussing employer liability and reproductive health, discrimination and harassment and hate crimes, and protected categories, including the addition of reproductive health. All right. And as we get started, I just want to remind everybody that these webinars are for general information. So like I mentioned, if you have specific questions about your business or about the regulation, reach out to us directly. We did get a question in the questions box. Yes, this is a California only webinar. We did cover the other states last week. So if you are not operating in California and you have no employees there, you can feel free to log off or sit around and listen to all the updates that are California. All right, so let's talk about protected time off and scope of coverage. So this regulation expands the definition of a family member, of a family member under the California Family Rights Act. and the California Health Workplaces Health Families Act to include a designated person. Employees will be able to identify a designated person for whom they want to use leave when they request unpaid CFRA or paid sick leave. That's what the Health Workplace Health Families Act is under. This goes into effect January 1st, 2023, as does every update we are talking about today. So please keep that in mind. And to answer some frequently asked questions on this, the bill does define designated person to actually mean any individual related by blood or whose association with the employee is the equivalent of a family relationship. The bill does authorize a designated person to be identified at the time the employee requests the leave, and the bill would authorize an employer to limit an employee to one designated person per 12-month period. So in other words, your employee cannot request sick leave for maybe a best friend who, they feel is equivalent to a family member, and then a month later requested for another designated individual. And these policies, along with many that we're going to be talking about today, should be updated in your handbook to reflect the above changes. So make sure you're updating your CFRA and your paid sick leave policies. All right, next we have wage transparency. This is another big update. So what is it? It requires employers of 100 or more contracted employees to submit separate annual pay data reports regarding the contracted employees. Also, and this is probably more relevant for all of you, it requires employers of 15 or more employees to provide the pay scale for a position in any job posting. This is also effective January 1st of the new year. The bill does revise the time frame in which a private employer is required to submit pay data reports. Reports must be provided on or before the second Wednesday of May of 2023, and for each year thereafter on or before the second Wednesday of May. The bill does require an employer upon request to provide to an employee, so those are existing employees, the pay, there's a typo there, sorry about that, pay scale for the position in which the employee is currently employed. And the bill requires an employer to maintain records of job titles and wage rate history for each employee for a specified time frame to be open to inspection by the Labor Commissioner. So, action item for all of you, time to update your job postings. And if you do not have salaries or a salary range for each position, it is time to come up with those and work with your HR professional to make sure those do exist so that they are available to your employee. All right, so we are still talking about COVID-19. The Workers' Compensation AB 1751 extends to January 1st, 2024, the current rebuttable presumption that an employee's illness resulting from COVID-19 was sustained in the course of employment for purposes of workers' compensation benefits. So once again, effective January 1st, existing law requires an employee to exhaust their paid sick leave benefits and meet specific certification requirements before receiving any temporary disability benefits, or for police officers, firefighters, and other specified employees, a leave of absence. This bill will expand the above described provisions applicable to firefighters and police officers to include active firefighting members of a fire department at the State Department of State Hospitals, as well as all of these other entities. So the rebuttable presumption is still in effect through January 1st of 2024. Not much has changed there aside from the expansion described below, but we just want to make sure it is on everybody's radar. All right, workplace posters related to COVID-19. So AB 2068 states that certain health and safety posters related to COVID-19 must be posted in additional languages. This is effective the first of the year. This bill requires that notices posted when the Division of Occupational Safety and Health issues a workplace health or safety citation or order to be written in the top 7 non-English languages used by limited English proficient adults in California, as determined by the most recent American Community Survey by the U.S. Census Bureau. So those include the languages listed below: Spanish, Cantonese, Mandarin, Vietnamese, Tagalog, Korean, and American. And the notices are always required to also be posted in Punjabi. And make sure that your posters are updated with the required language and in the with the required updates, as well as in the required languages. All right. For those of you just joining us, this is a California only webinar. So all of the updates we're discussing today are unique to the state of California. If you are not located in California and you want updates for other states, feel free to reach out to our team or check out our previous webinar. It occurred last week. So the AB 2693 is talking about exposure notifications. So this is a big one. Those of us who are in California know that when an employee had COVID, it was important to send out a variety of notifications. That is going to change. So this is going to amend the current labor code and extends its provisions until January 1st of 2024. The main modification will give employers the option to post a notice of potential COVID-19 exposure at the work site and on existing employee portals or company websites instead of actually providing a written notice. So this is going to save our employers quite a bit of time. This is once again effective the first of the year. This bill authorizes an employer to satisfy the notification requirements by displaying a notice in all places where notices to employees concerning workplace rules or regulations are customarily or normally posted. That includes the dates on which an employee with a confirmed case of COVID was on the worksite premises within the infectious period and the location of the exposure. For more information on what an infectious period is, do visit the CDC or the California Department of Public Health website. The bill would require the notice to remain posted for 15 days, and it requires an employer to keep a log of all the dates and notices, the dates the notice was posted, and the employer to allow the labor commissioner to access those records. And this bill also deletes the requirement of notifying the local public health agency of a COVID-19 outbreak. So I know, unfortunately, many of us are still experiencing COVID in the workplace and even COVID outbreaks. As of January 1st, 2023, this bill says you no longer have to contact the local health department to inform them of this. All right, let's talk about a big one. AB 1949, protected time off, bereavement leave. So this actually amends the CFRA to require employers with 5 or more employees to provide up to 5 days of unpaid bereavement leave for an employee within 3 months of the death of a family member. So prior to this regulation, there was no required bereavement leave in the state of California. So this definitely changes things. Make sure you are updating your benefits in your handbook or your benefits section or your bereavement leave policy specifically. Effective the first of the year, if the employer's existing leave policy provides for less than 5 days of paid bereavement leave, the employee is entitled to receive pay for the number of days provided in that policy, and the remaining days up to 5 days must be provided unpaid. If the employer's existing leave policy provides for less than 5 days of unpaid bereavement leave, the employee is entitled to that 5 days. So let's change those policies to reflect this update. The employee may use accrued paid leave otherwise available to the employee for the unpaid days. And as with CFRA, it is unlawful for the employer to refuse to hire, discharge, demote, fine, suspend, expel, or discriminate against an employee who exercises their right to bereavement leave. And lastly, this bill would require the employer to maintain employee confidentiality relating to bereavement leave as specified. A lot of changes coming to these handbooks. The next one we wanted to talk about is employer liability related to reproductive health. So this regulation actually prohibits a person from being subject to civil or criminal liability based on their actions or omissions with respect to their pregnancy or actual, potential, or alleged pregnancy outcome, or based on their actions to aid or assist a woman or pregnant person who is exercising their reproductive rights, effective the first of the year. And then this bill will provide for indemnification of employees or former employees of public agencies who are acting within the scope of their employment. And it doesn't stop there. Discrimination and harassment and hate crimes. This regulation actually expands the definition of hate crimes in places of employment to include display of hate imagery. I think we all can imagine what that means, but we do specify it for you below and provide examples. Make sure that you are updating your discrimination and harassment policies to reflect this new update. If you have no idea where to begin with all of these updates, definitely reach out to our team, and we're more than happy to assist in updating these policies on your behalf, or just working on a new handbook with you as well, or a state addendum. Next, we have reproductive health is now a protective category. So this amends the Fair Employment and Housing Act to prohibit employment discrimination on the basis of an individual's reproductive health decision-making, and expands required health plan coverage for contraceptives, effective the first of the year. This bill revises FEHA to include protection for reproductive health decision-making, as defined with respect to the opportunity to seek, obtain, and hold employment without discrimination. The bill prohibits certain discriminatory practices as well. Make sure you're updating those discrimination policies. And the bill makes it unlawful for an employer to require as a condition of employment, continued employment, or a benefit of employment, the disclosure of information relating to an applicant's or an employee's reproductive health decision making. For those of you who are just joining us, please do download the handout. We are covering a lot of information today, so we want to make sure you have a copy of everything. And yes, this is a California specific update. If you are operating in other states, or if you have employees in multiple states, definitely check out our webinar from last week where we cover many of those updates. All right. I know for some of you I sound like a broken record. I apologize. So we covered the core updates. Now we want to cover some focused updates. So the second half of our presentation is going to go over labor management relations, protected time off, FMLA paid, background checks, benefits regarding 401k, retirement and pension, garnishments. We're going to talk about the California Privacy Rights Act of 2020 and protected time off and non-retaliation. We'll talk about Title III accommodations as well. All right, so these focused updates. For the labor management relations, it actually permits an employee organization to file a claim against an employer before the PERB, spelled out for you, alleging violations of Government Code Section 3550, which prohibits a public employer from deterring or discouraging public employees or applicants from becoming or remaining members of an employee organization. This is effective the first of the year. The bill authorizes an employee organization to bring a claim before the PERB, alleging that a public employer violated the provisions. You can see we did list some civil penalty information, and the bill also requires the board to apply specified criteria when assessing the civil penalty. And our team did read through each of these bills very cautiously. So if you have questions, like I said, that we do not speak about or do not talk about during this webinar, reach out to us and we can help answer those questions to the best of our ability. Next, we have protected time off, SB 951, related to FMLA paid. This actually increases the amount of unemployment and wage replacement benefits for low-wage employees under the Family Temporary Disability Insurance Program for disabilities or covered incidents occurring on or after January 1st, 2025. However, the bill does go into effect January 1st of this coming year. It revises the formulas and extends the formula applicable for periods of disability commencing on and after January 1st of 2018, but before January 1st of 2023, through periods of disability commencing before January 1st of 2025, as said above. And the bill will redefine the weekly benefit amount. It also revises the formula for weekly benefit amounts under the Family Temporary Disability Insurance Program. All right, next we have background checks. So SB 731 amends the state penal code to provide for criminal record relief. It seals records of defendants convicted of most felonies on or after January 1 of 2005. if they completed their sentence, probation, supervision, parole, and any other terms of their conviction and are not convicted of a new felony for 4 years. I believe that is 4 consecutive years, but I'd have to double check on that. This is effective January 1st, 2023. The bill does state that conviction record relief does not affect the authority to receive or take adverse action based on criminal history information for purposes of teacher credentialing or employment in public education as specified. It also prohibits disclosure of information relating to a conviction for possession of specific controlled substances when the conviction is more than 5 years old and when relief has been granted under these provisions. All right, we have quite a few changes to 401ks. So specifically, this bill expands the definition of eligible employer under the CalSavers program to include those with 1 or more employees, requires employers with 1 or more employees that do not offer a retirement savings program to implement a payroll deposit retirement savings arrangement by December 31st of 2025. This does go into effect January 1st of the coming year. It does exclude from the definition of eligible employer any sole proprietorships, self-employed individuals, or other business entities that do not employ any individuals other than the owners of the business. And it requires eligible employers with 5 or more employees that do not offer a retirement savings program to have that payroll deposit savings arrangement to allow employees participation in the program within 36 months after the board opens the program for enrollment. All right, so for garnishments, this bill reduces the maximum number of wages that may be subject to garnishment effective January 1st. You can see that we list the percentages, so 20% of the individual's disposable earnings for that week or 40% of the amount by which the individual's disposable earnings for that week exceed 48 times the state minimum hourly wage. It also reduces the multipliers used to determine the maximum amount of earnings subject to levy for any period other than a weekly pay period. And the bill makes these provisions operative on September 1st of the new year. All right, and there were a lot of updates, 56 pages of updates to the California Privacy Rights Act of 2020. Well, not 56 pages of updates, but the act itself is about 56 pages. So definitely ask your HR professional if you have questions on this. But in summary, it expands the privacy and information security obligations of most employers doing business in California, requires significant changes to existing policies, procedures, and practices for handling HR individuals' personal information, and creates the Privacy Protection Agency to enforce the state consumer data privacy laws. We want to make sure that our handbooks are reflecting these updates. So once again, time to update your handbook for 2023 if you have not started that process. Protected time off related to non-retaliation. So we've gotten a few questions on this already. This prohibits an employer from taking adverse action, so demoting, terminating, etc., against an employee for refusing to report to or leaving work during an emergency condition if the employee has a reasonable belief that the workplace is unsafe. It also prohibits an employer from preventing an employee from accessing a mobile device during that time. So this is effective January 1st. You can require employees to provide notice in advance when feasible, or if advance notice is not feasible, as soon as possible. It entitles employees to use their cell phones or other device to get emergency assistance, communicate with someone to make sure they're safe, or assess the safety of a situation during an emergency condition. We do define emergency condition for you. And a health pandemic does not qualify as an emergency condition. Several types of employees are exempt, such as first responders and employees of licensed residential care facilities. Make sure you are reviewing your attendance policy, and if it requires advance notice for absences, add an exception when advance notice is not feasible because of emergency condition. All right, and then Title III accommodations. It requires businesses open to the public that have restrooms for employees to allow individuals who have certain medical conditions as listed to use the employee restroom effective January 1st. The bill permits the place of business to require individuals to present reasonable evidence of an eligible medical condition. And the bill would authorize the individual to satisfy that evidence requirement through a signed statement by a licensed physician, nurse practitioner, or physician assistant on a specified form to be developed by the State Department of Public Health and posted on its internet website. All right. There are other updates that we are not going to have time to cover today regarding industry-specific updates. So if you are in the fast food industry, call center, home health services, the employer liability human trafficking 1788 is for hotel employers. There's also updates to privacy surveillance, home care agencies, more on reproductive health and civil procedures. So if any of those interest you or you want to learn more, reach out to our team and we are more than happy to provide you with that information. Oh, as well as farm workers, my apologies. All right, so we provided a lot of information and we want you to take away those handouts and review them and ask the questions you may have. Do not hesitate to reach out to our team to learn more about our services. We can help you update your employee handbooks, keep up with these changes, and also help with day-to-day HR best practices, forms, policies, and more. And then our packages also include a learning management system with a broad array of employee and manager trainings, including state compliant harassment prevention training. All right. So as I mentioned, I don't think we're going to have too much time for questions today, but let me just double check in the questions box to make sure there aren't any pressing questions. All right. I don't see any. Email our team at hrservices@payentry.com if you have pressing questions, and we are more than happy to assist you. Thank you all for joining us today and for your time. Our webinars will begin again February of next year. We are taking the month of January off to reboot them a little bit, and we look forward to seeing you in 2023. Happy holidays and have a wonderful new year.